Please get ready for a dictation of exercise number 99 from legal material. 5 seconds. Start. From the perusal of contents of paragraph 4 of the counter affidavit, it transpires that the respondents have admitted the claim of the petitioner and the reason for non-payment, as has been assigned in the counter affidavit, is non-allocation of fund by the government for payment. After hearing learned counsel for the parties and perusing the record, we are unable to swallow the stand taken by the respondents in not releasing the payment when the work performed by the petitioner's father has not been disputed and liability of payment has been admitted. In such situation, it is incumbent upon the government to release the payment. From the bare perusal of contents of paragraph 4 of the counter affidavit, it transpires that respondent number 2 is writing letter after letter to the state government for releasing the payment, and it appears that even after respondent number 2's continuous effort, the payment is not being released by the state government. It is noticeable that the entire work has been completed by the petitioner's father, and in completion thereof he had invested huge amount of money. It is very strange that on the one hand the government has taken the work from the father of the petitioner, who had invested his own money in performing his part of the contract, and on the other hand the state government is lacking to perform its part of contract. We find that there appears to be no cogent reason for non-performance of the duty imposed upon the state government in releasing the payment in lieu of the completion of work under the contract. For such meager amount, the state can take shelter that there is no fund. We are of the view that the authorities working under government while entering into the agreement must be aware of their financial status, for which agreement has been entered into between the parties, and if the financial condition was not good, then the agreement should not have been entered into, and if it has been entered into, there must have been clear mention in the notice that fund is not available with the government, and the contractors are required to complete the work under contract, and as soon as fund is available, the payment be released. In absence of such mention in the notice, action of the respondents cannot said to be justified. We are of the view that the performance of the duty of the state and its officials must be above board. Here, in this case, we find that the respondents are taking a casual stand in not releasing the payment to the petitioner, whose father has performed his part of contract. The petitioner has also invested about 30,000 towards court fees in getting the succession certificate, and after submitting the succession certificate, only a meager amount of rupees 60,000 has been released in favor of the petitioner. The apex court in numerous cases has held that alternative remedy is not absolute bar, and in appropriate cases the petitions can be entertained under Article 226 of the Constitution of India. Stop.